right is still right, even if you stand by yourself.
Welcome to this week's edition of Case in Point for Thursday, February 27th, 2025. I am your host, Senior Legal Fellow here at the Heritage Foundation, Sarah Parshall Perry, and this is the legal show for regular people. No Washington doublespeak, no highfalutin Latin. We make it easy, we make it accessible, and we make it understandable. And boy, do we have a lot of legal news to cover today. Before I get to my guest, who writes and speaks and advocates and is in court talking about particular issues that I think many of us are concerned about right now. So first, I am back. You will notice we had a hiatus last week. I am back from lecturing at the University of Nebraska School of Law on Title IX and women's sports and sex-based rights in public education. And speaking of which, on Monday, we're going to see Senator Tommy Tuberville and Majority Leader Senator Thune advance SB 9. And that's a bill designed to specifically codify the definition of biological female and male into the text of Title IX of the Education Amendments of 1972. Yes, that law that keeps women's and men's facilities, private spaces, and athletics separate. So we will follow up with you next week on what exactly results after that vote. Also, SCOTUS has handed Trump a win on the USAID funding freeze. Now, remember that as a function of DOJ's insight to all of the federal funding and the waste, fraud, and abuse of the federal government, one of those particular directives was to stop the funding of overseas programs that were not only mission aligned, but were entirely wasteful to taxpayer dollars. Among those were, for example, $500,000 for transgender surgeries in Guatemala, a DEI musical in Ireland, and those types of mission aims. So Chief Justice John Roberts actually halted the lower court's order for Donald Trump to release USAID funding, and he issued the stay Wednesday night ahead of a midnight deadline, talk about the last minute, to disperse $2 billion in aid through USAID. It was one of the Trump administration's first targets to cut spending, but it is a temporary halt on the policy. In 2024, some of you who've followed along with some of the dollars and cents can recognize that USAID distributed close to $33 billion in aid, predominantly to causes in Africa and the Middle East. What else is on the news brackets today? Well, we have oral arguments scheduled in a couple of very high-profile cases that you, as listeners and viewers, will probably want to tune in for. Yesterday, we heard oral arguments in a case called Ohio Ames versus Ohio Department of Youth Services. Now, this has been structured as a reverse discrimination claim. A heterosexual woman, brought a employment discrimination claim under Title VII of the Civil Rights Act of 1964, which prohibits, among others, discrimination in any employment setting above 15 people, any basis on sex, national origin, race, religion, or national ethnicity, those particular categories that the Supreme Court has deemed to be protected under federal law. Well, she brought a discrimination claim because in her job at the Ohio Department of Youth Services, she was passed over for a promotion by a lesbian woman and later demoted in favor of a homosexual man. So how does a straight woman bring forth an employment discrimination claim? Well, the Sixth Circuit had determined she had to show background circumstances, which was beyond just what they called prima facie evidence of discrimination, then going to proof that her employer was one of those rare employers that would discriminate against an individual in a majority class, i.e., heterosexuals. Well, the Supreme Court heard oral arguments yesterday, and to my ear, it sounds like a majority of those justices don't want to add an extra layer of proof to any individual under Title VII, whether they are straight or gay, whether they are black or white, and that in the purpose of eliminating discrimination at Title IX, adding another layer for one class of individuals and not another would, in fact, be discriminatory. On March 31st at 10 a.m., we've got Catholic Charities Bureau versus Wisconsin Labor and Industry Review Commission scheduled to be heard. This is a First Amendment free exercise clause challenge to a state's denial of an otherwise generally available unemployment tax exemption to Catholic charities because its services to the poor were not deemed to be typical religious activity. In other words, they didn't proselytize, and it wasn't a typical church service or religious-oriented service. The organization doesn't evangelize program participants or limits employment to Catholics, and so are they religious enough to still gain that state tax exemption? You'll hear a little bit about this later in the program, but Mahmoud versus Taylor is scheduled for April 22nd. This is a free exercise challenge, again, religious liberty, to compulsory school indoctrination of elementary school students with gender ideology. No notice, no opportunity to opt out. This is a multi-faith coalition of parents who've all claimed the same thing. This interferes with their parental right to direct the religious upbringing and education of their children. And then on April 30th, we have the first case the Supreme Court will ever consider on religious charter schools. Charter schools, generally considered to be state agencies, organized and overseen by the state itself. This time, they will consider whether or not a religious organization, here, a Catholic virtual school, is constitutional, or does it somehow run afoul of the First Amendment's restriction on establishment of a religion by the government? So 3 big cases to watch on 3 very consequential issues. But there are also still awaiting some orders in cases we've heard. Remember the gender medicine case, U.S. versus Scarametti. We've also heard oral arguments and are awaiting decision on the Paxton versus Free Speech Coalition case, and that's relative to the regulation by a state of access to online porn by requiring age verification limits. We also have seen quite a number of particular short-form opinions in various cases that have so far already been heard. One of those is a case called Glossop versus Oklahoma, and the Supreme Court just 2 days ago came out with its decision in a 5-3 opinion. Gorsuch had recused himself. Justice Sotomayor is the one who wrote the opinion, and they sent a long-standing death penalty case back down for a new trial. Now, this was after a conviction in 1996. But the individual convicted, they determined, had not received a fair trial because, as it turns out, 7 boxes of evidence had been missing from the original case and had been hidden by the prosecution to the defense. So in something that reads a little bit like a John Grisham novel or a mystery movie, that is one of those times where you read an opinion and you really think to yourself, you know, if I had more time on my hands, I would indeed take up my pen and write a story about that. Lastly, a First Circuit decision just came out last week in a case called Foote versus Ludlow. This, too, is relative to the discussion I'm going to have today with my guest, Kate Anderson. Kate Anderson is Senior Counsel and Director of the Center for Parental Freedom at the Alliance Defending Freedom, and she is going to join me about a case coming out of Virginia, Figliola versus School Board of Harrisonburg, Virginia. What rights does a teacher have if they don't want to go along with compelled speech on things like preferred pronouns or hiding gender identity information from custodial parents of minor children? What rights does a teacher have? We hear often about the parental right, and we know that teachers have to give this information based on a correct legal analysis to parents when their child expresses a divergent gender identity at school. But teachers are now finding themselves in the crosshairs as well. Do they have a right to exercise their own religious liberty or their rights of free speech? And which is stronger in this particular case? The Supreme Court's understanding of First Amendment jurisprudence in the U.S. Constitution, or what the Virginia Supreme Court might have to say about the issue under state constitutional law. Kate Anderson joins us next on this week's edition of Case in Point. now on Case in Point is Kate Anderson. She is Senior Counsel with Alliance Defending Freedom and Director of their Center for Parental Rights, here to talk a little bit about something that is becoming increasingly worrisome, I think, for individuals like us who have kids in the education program. More than 1,400 school districts across the country have gender secrecy policies in place that keep information about a child's gender identity, expression at school, whether that's preferred pronouns or facility use, hidden from their custodial parents. It's not only worrisome and problematic for parents, it's also worrisome and problematic for teachers or administrators who might not want to, for moral or religious reasons or otherwise, want to go along with something that contravenes everything they know to be true about their right to dissent. Kate, thank you so much for joining me on Case in Point.
Thanks for having me.
Kate, talk to me a little bit about a particular case. It's Figliola versus School Board of Harrison, Virginia. Talk to me a little bit about what was at issue here and how this case came to be, how it came to Alliance Defending Freedom.
Yeah, so the Harrisonburg School District decided to train teachers specifically on one of these parent exclusion policies that you were talking about. They told teachers at a mandatory training that they had to immediately ask every student in their class for their preferred name and pronoun. They had to always use that preferred name and pronoun, and they needed to keep that secret from parents. This was of deep concern to both parents and teachers in the district.
Right.
So teachers came to us with concerns about doing this. They said, this violates my religious beliefs. This violates my beliefs about what it means to be a teacher. I want to work with parents. I don't want to hide information from parents. And so we ended up bringing a lawsuit on behalf of 3 teachers in Harrisonburg School District to challenge this requirement that they always ask for these names, always use them, and then keep it secret from parents. And we were successful.
You know, this is an interesting angle because 9 times out of 10, we hear about parental claims, about how there are claims based in, of course, the substantive due process of the 14th Amendment's due process clause, right? A
Right.
parent has a right to direct the upbringing, education, and welfare of their minor child. The Supreme Court recognized that over 100 years ago in Meyer versus Nebraska. But that's still sort of a shadowy right. We don't like to articulate unenumerated rights anyway. But this has sort of risen to new prominence, this idea of parental rights. And of course, the last time the Supreme Court weighed in was in 2000 in Troxel versus Granville. So we are a quarter century in before the parental right has been implicated again at the Supreme Court and under consideration, but this time it's the teachers. Was at any point ever their parental right claim involved in this particular litigation?
Yes, actually, teachers and parents came together when we originally filed the case, and there were a set of parents in the case that raised their own parental rights. But the court kicked those claims out right away at the very beginning of the case, in large part because those parents had not had their child secretly transitioned socially at school yet. And the court said, well, unless this has happened to your child yet, you can't be in court, which is a problem we're seeing in a lot of the cases going on this issue around the state. But here, the teachers stayed in the case and were able to vindicate both their rights and the parents' freedom through their free speech and religious freedom claims.
So and you had just mentioned about the parents' claim because they hadn't had a child who expressed gender dysphoria or who wasn't actually impacted by the direct policy, which is the wrong analysis, but this is the difference. And you have talked about it and written about it, and I've done the same, between a constitutional challenge that is an as-applied challenge. In other words, I have facts specifically that are impacted by this particular policy, and I can show you how it impacted me, or a facial challenge. In other words, this is unconstitutional as it applies to anybody, regardless of whether or not they have children who express this gender dysphoria. In fact, we saw 2 previous cert petitions at the Supreme Court, in a case coming out of the Fourth Circuit and another one coming out of the Seventh Circuit from Maryland and from Wisconsin, respectively. And the Supreme Court denied cert. My suspicion, and I'd love your perspective on this, is that those particular cert petitions were declined because they were both facial challenges. In other words, none of the parents in either set of cases could show that their children had expressed a transgender identity, that they were involved in hiding information from their parents. Do you sort of get that same sense?
I do. And you saw that in lower courts with some other cases, one in the Eighth Circuit out of Iowa, and other cases around the country. There seems like there's a discomfort among the courts in addressing this issue on what you're calling a facial point. But it really shouldn't be that way. Parents should be able to see this policy, see how it's going to be applied, and challenge it. And it's critically important that these policies be challenged, because by the time a parent finds out that this is happening to their kid, the harm's already done. And that last case that you mentioned, the case out of Wisconsin, you did have 3 justices at the U.S. Supreme Court say they think the case should be taken and they think the issue should be addressed on a facial basis at the lower courts. So I think there's going to be some movement on that. But at the same time, we're seeing a lot of as applied challenges come up through the courts.
Yeah. In fact, one that I mentioned at the beginning of the show was this First Circuit opinion in Foote versus Ludlow, which I found absolutely shocking. I began to read the opinion thinking that they were going to get it right, because they started out with a correct analysis saying, hey, listen, we recognize that the parental right is fundamental. We recognize that the Supreme Court in Troxel said it is the oldest of the fundamental rights we've ever recognized. But we don't think that this minor child, who was actually hiding information from her parents, was sufficient to actually interfere with the parental right, because they determined it was more akin to a curricular determination or an administrative determination, something which the federal courts have determined in the past parents don't really have a constitutional interest in. In other words, you drop your kid off and you have to be able to relegate some authority to the school to manage the school day as they see fit. I think they came to the wrong decision, but because this was a facial challenge, I'm hopeful, and in fact, everything I've read indicates that the plaintiffs in the First Circuit are going to make their way to the Supreme Court. Are you hopeful that when we see as applied challenges, the analysis might be easier and potentially a cert grant might be easier for the justices?
I am hopeful. I agree that the First Circuit got this wrong. This is clearly an invasion of parental rights, something that was harmful to this child and to this family. I do think that it is more likely to get a cert grant as you see these as applied challenges coming up, because the Supreme Court can hold on to more significant and specific facts. They can look at the case and how it impacted this particular person, and there's more for them to analyze in that context. But you're seeing this happen all over the country. We have a case in Michigan and a case in New York that are working their way up, where schools applied these principles to treat 2 different middle school age girls as if they were boys and hide it actively from their parents. In Michigan, the school district was even changing records, erasing names and putting in a different name so that they were hiding it from the parents. And those kinds of challenges show just how egregious these kinds of policies are to families.
Yeah, absolutely. We've got another one coming out of the 11th Circuit eventually, on which we are still waiting for the results of the rehearing en banc. En banc, obviously, meaning the entirety of the 11th Circuit panel. So they all sat in, they all heard oral arguments in a case called Littlejohn versus Leon County School District. And that is also an as-applied challenge. Teachers, administrators actively hiding gender identity information from the actual parents who had given them directives to say, don't you dare talk to my minor child about this. They went ahead and did it anyway, defying parental orders. And it wasn't until the minor child slipped when she was getting into the car to go to school and saying, oh, I met privately with teacher so-and-so, that the sort of specter of a problematic situation was raised. But that is another facial challenge that was argued in April of 2024. We are still waiting in February of 2025 for an outcome from a ruling of that particular 11th Circuit. Are you hopeful, based on what you know about the fact pattern in that case, the fact that it's an as-applied challenge, that the 11th Circuit will get it right?
I am. The 11th Circuit, I think, is open to the arguments, and you have an as applied challenge where there's very clear facts at play that the 11th Circuit can hold on to and say that in this circumstance, the way that this went down, this violated these parents' rights. And we're seeing this sort of, it comes out by mistake happening in a lot of these cases. And we're waiting a long time. I sort of speculate that the Supreme Court, part of the Supreme Court statement that they would have taken that facial case and that they want the lower courts to weigh in on these issues was trying to send a message to the courts that are holding on to these cases and not deciding, because there's also one, I believe, pending in the Ninth Circuit
Yeah.
that we're waiting on a decision on. So these are kind of out there. The courts aren't sure what to do with them, and they need to start weighing in.
So let me ask you one more question about the parental right aspect of these school secrecy policies, specifically related to a case that we're going to hear oral arguments on in April. And I didn't think they would schedule it for oral arguments that soon. I actually thought they would punt the scheduling until the next term, because we really are now almost into March, and it will be a few short months before the term ends at the beginning of, or at the end of June, beginning of July. But there is a case they've just taken up and set on the calendar for oral argument called Mahmoud versus Taylor. And this is a religious coalition, a multi-faith religious coalition of parents who have said that in Montgomery County, Maryland, and again, that is the origin for another one of these school secrecy cases that was kicked out, that was declined to be taken up. But this particular claim is that their minor children, and these were kids 4, 5, 6 years old, were getting instruction in the earliest educational grades about gender identity, which was a violation of not only their parental right, but their right to specifically exercise their religious freedom and bring their own children up in the faith and the traditions and understandings of right and wrong that they wanted to. Do you think that particular case could be easily decided on a free exercise claim, or are they going to have to wrestle specifically with the parental right in this Mahmoud versus Taylor case?
I'd like them to reach the parental right. I think they could decide it on a free exercise basis, which we've seen the court do before, decide a case on a particular constitutional grounds and leave the other issues for another day. But this case really goes to the heart of what you were talking about earlier with curriculum cases. There was a string of cases in the courts of appeals across the country that came out really poorly for parental rights on questions of curriculum and how much parents can influence and opt their children out of curriculum they object to. And I think there the court was trying to balance the regular administration of the schools, giving the schools freedom to do that against the parental right. I think they swung far too far, because you have language in some of those cases, one particularly in the Ninth Circuit, that said parents lose their rights when they drop their kids at the schoolhouse gate. And that's the world we've been living in that has led to secret transition cases and policies in these districts, and cases like the Mahmoud case, where you have very, very young kids who are too young to even know how to tie their own shoes, being taught about gender identity and informed by their teachers that they might be born in the wrong body, and all of these things that many parents of many different backgrounds have a clear objection to.
So let me talk a little bit about the teachers, because theirs were the claims that could go forward in this particular case. I would love to know why your firm decided, why Alliance Defending Freedom decided to bring these claims under state law as opposed to federal law, because one would think the First Amendment of the Constitution, the free exercise clause and the free speech clause, both would protect these teachers. And we've got a pretty good, robust Supreme Court, at least when it comes to free exercise, and to a certain extent, about as much on free speech, at least under its current composition. We've seen a lot of good First Amendment jurisprudence, but why not bring it under federal constitutional law? Why state claims?
Well, I think that the federal constitutional rights under free speech are very, very strong. But sometimes the state constitution is stronger. And there was a lot of great case law and precedent in the Virginia state constitution that said that that free speech is protected. And we thought that those claims were probably stronger there, as well as we originally had the parents involved, and Virginia has a parental rights statute that we wanted to bring the case under. That ultimately didn't work, because the court decided that the parents couldn't actually bring their own cause of action, their own lawsuit under that state statute. But it did work out for us on the constitutional free speech, religious freedom claims, and those did prove stronger in the state system than in the federal system.
So let me talk about these teachers specifically. They are individuals who have advanced this perspective under state constitutional law. And you mentioned state constitutional law and the strength of state constitutional law in Virginia and the Virginia Constitution. We've also seen a related case, the Peter Vlaming case, the middle school
Yes.
French teacher who refused to use preferred pronouns because it violated his religious liberty, his rights of free speech under the Virginia Constitution as well. So it seems to me, and of course the federal circuit that's applicable here would be the Fourth Circuit, they've been not so great on the notion of gender identity and First Amendment rights. So strategically, this is a great decision. But of these three teachers, did any of them, or did all of them, advance not just free speech rights, but also free exercise rights and their religious liberty, which was implicated here?
Yes, absolutely. They were bringing both issues. They were saying that it is their First Amendment right to be able to speak freely and not be compelled by the government to either speak a message about gender identity by using preferred pronouns that they object to, or by being restricted in their speech in being prevented from talking to parents. And you mentioned the Vlaming case. It was a very similar case that came from a French teacher at West Point, and that case worked its way up to the Supreme Court in Virginia, and the Supreme Court Virginia agreed on both points, that Mr. Vlaming had the freedom of speech not to be forced to use pronouns, and that it violated his religious freedom. And then that case in turn impacted ours, as you sometimes see. When the Supreme Court of the state has weighed in so strongly on that issue, we then were able to resolve our case by agreement with the school district, and the school district there agreed not only that they would not require any teachers to ask for pronouns or use pronouns, but they also, even though the parents' claim had dropped out, they agreed that they would not support any lying to parents or hiding information from parents by any teacher in the district, which is a great thing for both parents and the teachers involved.
Yeah, absolutely. So where is this case now? And really, what is the next step for teachers in the state of Virginia, in your mind?
Well, our case was able to resolve in December, so it is over with a win by agreement from the school district, as I was just talking about, agreeing to those three great points, that they wouldn't require teachers to do these things and they wouldn't allow them to lie to parents. And so that means that within Harrisonburg School District, teachers are free. They're able to speak according to their conscience, and parents don't have to worry that the school is going to lie to them. And this is a question, though, that's going on in many districts in the state. And in Virginia in particular, you have an attorney general that's concerned with this particular issue and has issued model policies, encouraging school districts to strike a proper balance where they're respecting kids and the things that they need and working with them, but not forcing any teachers to violate their conscience or their free speech rights, and certainly not hiding information from parents. I think one thing that should be added here is that kids that are struggling with these issues really need their parents. And that's why it's so dangerous to try to drive this wedge between parents and kids and hide this information from parents. They really need their parents to be coming alongside them and helping them deal with these really challenging issues.
For teachers and administrators, like the teachers involved in the Figliola case, what would you say to them if they are not in the Harrisonburg School District and they are dealing with a policy like this? Because we realize, again, with 1,400 of these policies nationwide, and that represents about 12 million school students, they've proliferated with incredible speed. So there may be other parts of Virginia, in fact, I would virtually guarantee it, that are still instituting, have inculcated gender identity, that are refusing to accept the disagreement, the dissent of teachers or administrators who don't want to lie to parents because it is, in their mind, amoral or it is a violation of their religious freedom. What would you tell them if they don't have the benefit of a protective settlement agreement and a great decision to rely on?
I would tell them to look at their policies, find out what's being required. And even if they're not in written policies, sometimes this is in teacher training. Talk to their school and find out what they're required to do. And then the Vlaming decision should protect them. The fact that the Supreme Court of the state came in and said that in this kind of a situation, it violates free speech and religious freedom to force a teacher to to use pronouns that violate their conscience and to help participate essentially in a secret social transition, that decision is protective of them. There's also litigation going on in other districts that could be helpful. There has been litigation in Fairfax County. There's been litigation in Loudoun County that we've been involved in. And so there are other cases out there that could be helpful. And then if you're still having problems, feel free to call Alliance Defending Freedom or other organizations in the state that are paying attention to these issues and trying to help teachers.
So on a scale of 1 to 10 right now, Kate, how busy is the Center for Parental Rights?
We are very busy. We have 5 full-time attorneys focused entirely on parental rights. This is a big part of our litigation, these particular policies helping teachers and parents and kids. And we had, I think, 4 new cases come in just last week that we're getting engaged in. And so it's busy. It's very, very busy.
Well, I suppose it's good for you guys, sort of endemic to where we find ourselves culturally right now. But thank God for the work that you guys do there and for the Center for Parental Rights. Thank you, Kate, for joining me on Case in Point.
Thank you for having me.
Well, that's it for this week's edition of Case in Point. I have been your host, Sarah Parshall Perry. I hope you have been enlightened, possibly entertained, encouraged, and instructed in ways that make you understand that the law works for all of us, especially regular people like you and me. Follow us on X at Case in Point Pod and share this podcast with friends and family who might use a little law in their lives. Our podcast is available on all your regular standard platforms, including YouTube, Apple, Spotify, Rumble, and all the other regular ones that my kids know, but I don't. Until then, friends, court is adjourned.